This is an episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. So, in this episode, we're going to talk about the types of company meetings. So, company law has not defined, or it has no specific definition of what a company meeting is. Neither do the courts provide a legal definition of a company meeting. So in general terms, a company meeting refers to a gathering of persons, and Lord Coleridge, in the case of Sharp versus Dawes, provides this definition of a company meeting, and according to him, he says that a company meeting is a prima facie gathering of more than one person. So the case of Sharp versus Dawes is a guiding case, is a leading case that provides guidance on company meetings. So that case of Sharp versus Dawes, it's an important case where Sharp conducted a meeting of two people, and they were testing the validity of that meeting. So we're going also to look at that case together with the exemptions that were brought out in that case, and the exemptions provide for one person that a meeting that is attended by one person is a valid meeting under the exemptions in that case. So in this episode, we're going to talk about these 5 types of company meetings. And the types of company meetings are the annual general meeting, we've got the extraordinary meeting, we've got the class meeting, we've got the director meeting, and we also have the statutory meeting. So the annual general meeting, the AGM, is a type of meeting that is mostly carried out by public companies. So this is a meeting that is convened after a notice has been given. So in an AGM or an annual general meeting, a notice is usually 21 days, but in a general meeting, a notice of 14 days is supposed to be issued to the shareholders of a particular company. So a meeting cannot be issued in circumstances whereby the resolutions to be passed within a particular meeting are invalid resolution or void resolution, or if these resolutions to be passed are defamatory resolutions, or if they are defamatory resolutions, then a meeting cannot a notice cannot be passed. So if also these resolutions are frivolous or zealous, this meeting resolution cannot be passed, or a notice cannot be issued. So a notice cannot be issued in an invalid a meeting of invalid resolution, void resolution, frivolous or zealous resolution, or a defamatory resolution. So a general meeting, the agenda that is discussed here are agendas like election of directors, declaration of dividends, and appointment of remunerators or auditors, and other activities of the amount of sharing of dividends and declaration of dividends and profits, and other activities that are conducted. So the second type of meeting is the extraordinary meeting, and this is a general meeting that is conducted or convened when there is a particular need or specific need. So a director can conduct this type of meeting, or can convene this type of meeting. So a notice is supposed to be passed before this meeting is conducted. So a notice is also issued for this type of meeting. So it's the meeting that is conducted when there is need. So the third type of meeting is the director meeting. And the director meeting, this is the meeting that is conducted or convened by board members. So this is the meeting that is attended by board members. So the director is the one that so the board members don't attend this meeting, and the director chooses the forum to attend, or the number of people, who are supposed to attend in this meeting. So if the director does not specify the people, the exact number, then the forum is supposed to be 2 people. So the resolutions here are things like recommendation of dividends and appointment of directors, secretaries of the company, and the buying of dividends and other activities that are carried on in that type of meeting. So another type of meeting is a class meeting, and a class meeting is a meeting that is carried on in a company whose capital is divided in a class of shares. So a meeting whose capital is divided in a class of shares shall conduct or can conduct a class meeting. So the resolution here depend on the shareholders. They can just meet to discuss about shareholders. They can just meet to discuss about the shares or the capital of a particular company. So another type of meeting is the statutory meeting, and this is a type of meeting that is convened after a statutory declaration. So according to section 41 of the Companies Act, this is the type of meeting that has got statutory, like this, just a statutory that is guided by the statute. And this is the meeting that people meet to discuss about the statutory report. So the main thing here is the statutory report, and the content of this statutory report is it's about the managers of that company, the directing managerial directors, the managers, the secretaries are contained in that statutory report, the shareholders and the amount of shares and other contents in that statutory report. So the case of Sharp versus Dawes is an important case, the guiding case that of a meeting. This is whereby Sharp wanted to conduct a meeting and pass a resolution of a cause. So he went on and carried on and went on with the meeting and appointed just a secretary and took the minutes, and he passed that resolution. So later on, people went to sue against that resolution, but the court, they wanted to invalidate that meeting because it was attended by 2 people. But the court held that 2 people are sufficient, or 2 people are enough for a meeting to be conducted. So that is the leading case of Sharp versus Dawes, and that one provided guidelines to a meeting. So we've got the exemptions to Sharp versus Dawes, and the exemption provides that a meeting can be attended by even one person. So the exemptions here, we've got class meeting, exemption of a class meeting, and we've got another exemptions like a meeting that has been conducted by the order of court. When the court has provided that order for the meeting to be conducted, can be an exemption. One person can attend. And another exemption is a meeting that has been adjourned, an adjourned meeting. So where the director has called for a meeting, and after 30 minutes, no one has come, no one has appeared, then that meeting can be adjourned, and that meeting will be considered as an adjourned meeting of 1 member. So that is also another exemption. And another exemption is of what are the exemption? Creditors meeting. So after a meeting has been after winding up of a company, only one creditor has proved his claim. So that one will be constitute a meeting of creditors for the purposes of winding up. So those are the exemptions. And we also have directors meetings, and where a private company has only one director, that director constitutes a director meeting for the purposes of that company. So those are the exemptions to the rule of in Sharp versus Dawes. So Sharp versus Dawes is an important case law. So Annual general meeting is provided for under section 3 subsection 10 of the Companies Act, and consideration of accounts and other activities that can be conducted within that particular meeting. I forgot to tell you that. And extraordinary meeting is provided for in section 276 and 277 of the Companies Act. So class meeting, we also have directors meeting, and other activities that can be carried on include company borrowings and recommendation of dividends, payment of interim dividends, and appointment of managers and company secretaries. So statutory meetings, 6th schedule of section 41 considers that a special meeting can be held by the public companies once in their life. So this type of meeting is held once in the lifetime of the company. And the content of the statutory report include the total number of shares that are noted, the total amount of cash received by the company, the abstract of receipt on the company, and the other receipt of the company and other payments made by the company are contained in the statutory report. The names and description of directors and auditors, the managing directors, the company secretaries, they are contained in the statutory report. The particulars of any contract that the company is party to, auditors and certificate of shares are also noted, and the cash received and payment are also contained in the statutory report. So that is the end of my episode about company meetings. So subscribe to Scores Legal channel and stay notified about the content in law. And come on, you guys, have a nice day, and we're gonna do this.